Welcome to Law Family. This video is helpful to the law students and newly practicing young advocates only. Today, we discuss about the sections 39, 1 and section 72 of BSA Act 72 of BSA Act 2023. Corresponding law section is 45, 45A and 73 of Indian Evidence Act. Section 39(1) of BSA Act 2023 defines the opinion of experts, and Section 72 of BSA Act defines comparison of signatures, writing or seal with the others and admitted or proved. Further, the two sections discuss the interplay between expert opinion and judicial comparison for handwriting and signatures. Under Section 72 of BSA Act, corresponding law Section 73 of Evidence Act, the court is having authority to compare the disputed handwriting, signature, finger impressions with the admitted handwriting, signature, finger impressions without the assistance of the expert, but it is considered to be the hazardous and risky. Under Section 39 of BSA Act, corresponding law Section 45 of Indian Evidence Act, which defines the identity of handwriting or finger impressions, the opinions upon that point of persons specially skilled in such foreign law, science or art or any other field or in questions as to identity of handwriting or finger impressions are relevant facts, and such persons are called experts. Sections 39(1), 72 and Section 119 of BSA Act, corresponding law section is 45, 73 and 114 of Indian Evidence Act. Handwriting experts' opinion can be called by the court through the court itself is having power to come to its own conclusion. Article 21 of the Indian Constitution came to the conclusion that the fair trial demands full opportunity of defense to the petitioner. Important point here is what should be the nature of evidence is not a matter, and which should be left only to the discretion of the court. Hence, the court has to exercise its jurisdiction judiciously to see that a proper and fair opportunity of defense is given to the petitioner. Under Section 72 of BSA Act, corresponding law section is 73 of Evidence Act, the court may direct any person present in court to write any words or figures for the purpose of enabling the court to compare the words or figures. So, written with any words or figures alleged to have been written by such person, that is petitioner. This section applies also with any necessary modifications to finger impressions. The important point in this section is it is not always necessary to send the document for FSL, that is forensic lab, or forensic lab, or handwriting expert's opinion when the court itself is in a position to draw its conclusion. But such conclusion cannot be drawn safely. Better to seek an expert opinion. Further, the cases are divided into two sets, only in which an expert opinion has been sought by the court at the instance of both the parties or one party. The court has to draw its own opinion thereafter, and in other set of cases, no expert opinion was sought by the party. The court can record its own opinion after comparing two writings, TWO, two writings, and signatures. In all cases, ultimately, conclusion has to be drawn by the court after taking note of the corroborative evidence with that of the opinion of the handwriting expert. Thus, in the cases where handwriting expert's opinion is sought, it may not be accepted without corroborative piece of evidence. In fact, if such a proposition is accepted, then sections 39(1) and 72 of BSA Act, corresponding section 45 and 73 of Evidence Act will become redundant.
Important case laws. Party can examine private expert on his own behalf without appointment by court. The expert's opinion based on observations or experiments is relevant in cases where questions relating to his science arise. Third point, expert evidence. Fact that expert was competent to give expert evidence must be proved. Law does not permit assumption without evidence on material point of competence. Fourth case. Photographer examined. Negative not produced. Person who developed not examined. Reliance cannot be placed on photographer. Fifth case. Court should take pains to have the expert explain in court the reasons for his opinion. Sixth case. Magistrate bound to summon and examine handwriting expert at any stage of the trial, even without any suggestions emanating from the prosecution. Seventh law. Examination by handwriting expert is not necessary in every case of disputed writing, and no adverse inference can be drawn for not obtaining expert opinion in such case. Eighth case. Expert opinion must be given orally. Ninth case. Conflict between opinions of medical witnesses and opinion of that expert which supports direct evidence should be accepted. Important point. Conflict between opinions of medical witnesses and opinion of that expert which supports direct evidence should be accepted. 10th case. In examining a disputed document, the true test is not the extent of similarities observed when compared with genuine document, as forged documents usually are good imitations of genuine documents, but the nature and extent of dissimilarities notices. 11th case. Section 39 and 72 of BSA Act, corresponding law section 45 and 73 of Evidence Act are no bar for the judge himself comparing admitted signatures with disputed signature. 12th case. The court has to apply its own mind and eyes and verify results submitted to it by experts. 13th case. 13th law. Evidence of footprints obviously very much less trustworthy than evidence with regard to fingerprints. 14th. Evidence of the expert should be accepted with great caution. Power given to court to compare signatures on question documents and come to its own conclusions irrespective of the report of expert. 15th case. It is not essential that the handwriting expert must be examined in a court to prove or disprove disputed writing. Next, repeated. It is not essential that the handwriting expert must be examined in a court to prove or disprove disputed writing. 16th. Opinion of handwriting expert not substantive evidence. Court entitled to compare handwritings for purpose of assessing the opinion of the expert but not to form its own conclusion as an expert. 17th. No rule of law or produce receiving corroborative of opinion evidence produce requiring corroborative opinion evidence, but it can be one of caution having due regard to the imperfect nature of the science of handwriting. No rule of law or produce requiring corroborative of opinion evidence, but it can be one of caution having due regard to the imperfect nature of the science of handwriting. This video is purely theory. The Honorable Court decides each case on merits.
Thank you.
Thank you.